In a move that has legal buffs and pop culture enthusiasts leaning in, the legal teams have just thrown a massive flag onto the court docket. Just as we were all bracing for the fireworks of a trial, the latest filing reveals that the attorneys are essentially asking the judge for a timeout. It's a classic case of legal chicken, where nobody wants to blink or file a motion until they know exactly what the battlefield looks like. But why the sudden cold feet? Is the trial in danger of disappearing entirely, or is this just the calm before a very expensive storm? Attorney Shapiro, representing the Wayfarer parties, recently filed a request to adjourn the pretrial deadlines. In plain English, they're asking for a hall pass. They want to push back the dates for the heavy lifting filings because, frankly, they are in a state of suspended animation. Imagine being a chef told to prepare a 5-course meal, but the host hasn't decided yet if the guests are vegan, keto, or allergic to everything. You could start cooking everything, but you'd likely end up throwing half the food in the trash. In legal terms, these meals are called motions in limine. These are critical requests made to the judge to keep certain evidence out of the trial. If a piece of evidence is too spicy or irrelevant, a lawyer will fight to ensure the jury never sees it. However, the parties are currently awaiting an order on dispositive motions, the rulings that determine which claims are strong enough to go to trial and which are getting tossed in the bin. The attorneys are arguing that it's a waste of the court's time and their clients' money to file motions about claims that might not even exist by next week. It's a logical move, but in law, logic often clashes with a calendar. Will the judge see this as a reasonable request for efficiency, or just a clever way to stall the inevitable? When it comes to the actual schedule, the two sides are playing very different games. Blake Lively's counsel is playing it safe and structured. They've consented to an extension, but they want hard deadlines. They've proposed moving the pretrial filings to April 3rd, with oppositions following on April 10th. The Wayfarer side is looking for something a bit more nebulous. They've proposed that the clock shouldn't even start ticking until 21 days after the court rules on the current motions. Lively wants to know exactly when the homework is due. Wayfarer wants the homework to be due 3 weeks after the teacher finishes grading the last test. Why the friction? If you're the Lively side, you're worried about the crunch. If the judge takes forever to rule and finally drops the order just days before the trial is supposed to start, a 21-day window could push the trial date back yet again. No one wants to be prepared for a sprint only to find out the race has been moved to next year. But what happens if the judge decides neither plan is perfect? Is there a middle ground that satisfies both the celebrity plaintiff and the corporate giant? Whenever two sides can't agree, we look to the bench. In this case, the judge is facing a classic split the baby scenario. In legal lore, splitting the baby refers to a compromise that gives both sides a bit of what they want but satisfies neither completely. The judge knows that the court's calendar is already a nightmare. This trial has already been moved once, reluctantly, because of the court's own scheduling conflicts between criminal and civil cases. Criminal cases always win. Because of the constitutional right to a speedy trial, criminal defendants get the HOV lane on the court docket. Civil cases, like Lively versus Wayfarer, are stuck in the regular lanes, hoping there isn't a wreck up ahead. The judge is likely to push for a compromise, perhaps a 7 or 14-day window following the ruling. The court's primary goal? Protect the trial date at all costs. Judges hate moving trials because it ripples through their entire year, affecting dozens of other cases and hundreds of people. We are standing at a fascinating crossroads in the Lively versus Wayfarer saga. On one side, we have a legal team trying to protect their client from unnecessary work. On the other, a team trying to ensure the wheels of justice don't grind to a halt. At its heart, this isn't just about paperwork. It's about strategy, timing, and the immense pressure of the big stage. Whether the judge grants the 21-day window or sticks to the April 3rd deadline, the clock is ticking, and the world is watching. What do you think? Should the judge give them the 3 weeks they're asking for to ensure the trial is clean, or should they be forced to stick to the original plan to avoid more delays? Drop a comment below with your take on this legal chess match. If you found this breakdown helpful, share it with a friend who's been following the case.